with the defendants. The claimant had a year spell of industrial training with the defendants. Thus, she was not placed on probation, but confirmed as an employee of the defendant following her engagement. She was also entitled to certain benefits, including but not limited to gratuity payments. Sometime in the year 2016, the defendant sent out a notice informing its employees that it was undergoing restructuring owing to financial challenge or economic downturn. As part of the restructuring, employees were required to sign a pledge form affirming that they voluntarily assent to the conversion of their employment to becoming contract staff. The claimant signed the said pledge from the claimant signed the said pledge form agreeing to be a contract staff and subsequently determined her employment to the defendant, claiming that the defendant was indebted to her for certain benefits that remains outstanding. Whereof the claimant seeks against the defendant as per her amended general form of complaint and statement of fact the following. A declaration that the notice to all permanent / confirmed staff signed and dated the 4th day of October 2016 and handed over to the claimant, and the subsequent acceptance of the temporary conversion of a permanent / confirmed employment to contract employment are null and void, them having been made under deceit, coercion, contrary to labor practices. B, a declaration that the purported verbal termination of the claimant's employment without due notice is wrongful, null and void. C, a declaration that the non-payment of the claimant's salaries and allowances from September 2016 to date, final entitlements and non-remittance of payee and pension deductions are wrongful. D, awards of the following against the dependent company. A, 1, the sum of 296,492 naira, being balance of the admitted 785,388 naira, unremitted and unpaid pension and gratuity due to the claimant as at 31st of December 2016. B, this one is in Roman figure. Roman figure 2, the remittance of the sum of 220,000 naira to the Lagos State government, being the claimant's unremitted payee deductions from January 2009 to September 2009, providing the defendant with physical proof. 3, the sum of 186,200 naira unpaid claimant's allowances to for September 2018 to December 2015 at the rate of 46,550 naira per month. 4. Unpaid salaries and allowances of the claimants from January 2017 until judgment is given in this matter at the rate of 73,317 naira per month. 5. The sum of 73,317 naira being payment in lieu of notice of termination of employment. 6. The sum of 500,000 naira being cost of filing this suit. The defendant, upon entering appearance, filed its statement of defense on 27th day of March 2017, and later, with the amendment of the statement of facts by the claimant, filed its consequential amendment statement of defense dated 20th day of December 2017. The claimant, in response to the defendant's amended statement of defense, filed with the order of the court an amended reply dated the 28th day of December 2017, but filed on the 2nd day of January 2018. Trial. The claimant testified as CW1. She adopted and written the positions as her evidence in chief. Through her, some documents were tendered in evidence, which were admitted and marked as exhibit C1 to C12, respectively. The claimant was duly cross-examined by the defense counsel, and there was no re-examination. Thereafter, the claimant closed her case. Learned defense counsel had, during the proceedings, approached the court, notifying the court that, quote, the defendant was no longer a going concern, so it will not proceed further with his defense, unquote. After giving the defendant opportunity to enter his defense, the matter was adjourned for adoption of addresses. The claimant, in her own final written address, formulated the issue below for determination, and that is to say, A, whether by virtue of the internal memo of the 4th day of December 2016, the employment of the claimant was validly converted by the defendant from permanent confirmed employment to contract employment. B, if not, A, whether by orally preventing and stopping the claimant from entering the company premises to continue her work, the employment of the claimant was validly terminated by the defendant. And 2, whether the claimant is entitled to the claim orders and awards that fit. Then the learned counsel went ahead and made his submission on this final written address. We cited cases to buttress whatever points he made, and actually he went to town on his final written address. So, just a minute. Okay. And the learned claimant's counsel argued that other issues formulated interfacing his submission with relevant authorities. He also made submissions on why the claims of the claimant should be granted. Counsel urged the court to grant the claimant's claims. So in resolution, the court considered the facts and circumstances of the instance suit as reflected in the various pleadings, the evidence adduced, and the submissions of counsel, and distilled the issue below for determination. And these are the issue below is, has the claimant proven her case to entitle her to the relief sought hearing? Then the court went on to say the records of the court discloses the defendant's hearing upon being served on the originating processes, entered appearance and all that. The court went ahead and put down what transpired in the court. Then assessed the submissions of the learned counsel to the claimants, which submission was significant, lengthy, but full of substance. Yes. And the court tried to appraise each of the submissions with the position of the law to see whether that they are the positions, the current positions of the law. And at the end of it, the court gave his own opinions on each of the submissions. But I cannot read the opinions of the law or the opinions of the court without going through the whole course of the submission. So that is why, like we all agreed before, the court is going to the very end of the judgment, knowing that both learned counsel can read the judgment fully and then take his own stand on what to do with the judgment, either to let it fly or to appeal against it. So I will start from paragraph 53. Then is the claim seeking the award against the defendant's company, the sum of 500,000 naira, being cost of filing this suit. As argued by the learned claimant's counsel, cost follows events, and the successful party is entitled to the cost of prosecuting or defending the action, either wholly or partly, unless he misconducts himself in such a manner that deprives him of such an award. See the case of Ubani Okoma versus 7-Up Bottling Company and another, reported in 2022. Citation supplied. See also MultiChoice Nigeria Limited versus Adiogun, reported in 2023. Citations also fully supplied. It is a Court of Appeal case. Now, also, the award of cost is at the discretion of the court, which discretion should be exercised judicially and judiciously. This court is of the considered view that the circumstances of this suit is such that makes it judicious to exercise its discretion in favor of the claimant. See the case of Yakubu versus Ministry of Housing and Environment, Bauchi State, reported in 2021, 12 Nigeria Weekly Law Report, part 1791, page 455. Accordingly, this relief succeeds, and the court awards against the defendant the sum of 500,000 naira as cost of this suit. And I so hold.
As the accomplices.
Yes, no. The issue for determination is resolved partly in favor of the claimant given that part of her claims before the court succeeds, as will be outlined below. So, save the claims outlined below. All other relief sought by the claimant fail and are accordingly dismissed. The orders
As a
of the
company.
court are as follows. A. It is declared that the purported vertical termination of the claimant's employment without due notice is wrongful. B. It is declared that the non-remittance of pension deductions by the defendant is wrongful. C. The court awards against the defendant 1. The sum of 296,492 naira, being balance of the admitted 785,388 naira, unremitted and unpaid pension and gratuity due to the claimant as at 31st December 2016. 2. The sum of 26,767 naira, being payment in lieu of notice of termination of employment. And 3, the sum of 500,000 naira as cost of this suit. This is the judgment of the court and it is entered accordingly.
As accomplices. My Lord, we are
Yes,
most grateful for the precious time of the court and for going through painstakingly the whole submissions of counsel. We are most
yes.
grateful, my Lord. Yes, we are most grateful.
And thank you for agreeing with me to take the first and the last part. You know
No
how it
problem.
is.
No
Yes,
problem, my Lord. We are most grateful, man. We are
very well.
grateful.
Thank you,
Thank you,
very
man.
well.
Thank you.
Okay.
Thank you, man.
All right. So I don't know, there's another ruling. Is there anybody here for the ruling?
Yes, my lord.
Hello.
Okay. Um, your name, please,
Johab Abo for the third defendant.
for the first defendant. Okay.
Third, Green
Third.
Africa.
Okay, for the
Yes,
third. Okay.
yes, yes, sir.
How about the first and second defendants? Are they represented there? However, I'll go ahead and
My lord, and for the
yes.
claimant, my lord, Ibukun Idris for the claimant. I believe the matter is Overland and Olamide Akinfolari, my lord.
Overland Airways Limited.
Yes, my lord.
So Olamide Akinfolari,
Yes, my
Captain Fola Yele Akin Kuotu, and the
yes,
Green African Airways Limited.
yes, my lord.
And you're for the third defendant.
My lord, Ibukun Idris is for the claimant, my lord.
Okay. All right. First claimant. How about the first defendant? Is it represented by counsel? Is a counsel here?
No, my
No.
lord.
How about the second?
No, my
The
lord.
counsel. Okay. Now the third, please let me have your name.
Johab Abo. Johab Johap.
Okay.
Abo
Abo.
AGBO. Yes, yes, my lord.
Very well. For the third defendant. So this is the ruling of the court on an application brought by way of a preliminary objection dated and filed on the 6th day of March 2023, pursuant to relevant laws, rules of court, and under the inherent jurisdiction of this honorable court by the first defendant applicant, seeking the following relief. A. An order striking out the claimant's respondent's suit in its entirety for want of jurisdiction. The second prayer is the omnibus prayer, and the grounds upon which the application is brought are as contained on the face of the application. The application is supported by a 15-paragraph affidavit deposed by Ms. by Ms. Olumide Akinfolani, the first defendant hearing. The applicant raised an issue for determination in his written address, to which, having regard to the subject matter of this suit, whether this honorable court has jurisdiction to entertain this suit as presently constituted. The first defendant applicant states that the only issue between the parties border on debt recovery, and the only dispute between them is the actual bond sum and the manner of repayment of same. That there was no subsisting employer-employee relationship or any dispute related thereto between the parties, as at the time the cause of action in dispute arose, and there is still no such relationship or dispute between them. The defendant applicant counsel argued that the National Industrial Court lacks jurisdiction to entertain this suit because it is purely a debt recovery matter, not an employment-related dispute. Counsel cited the case of Aja versus Commissioner of Police, Ebonyi State, and others, reported in 2020, citations supplied. And also, the FCC Nigeria Limited and another versus Joseph and another, reported in 2020, citations fully supplied. Both cases are Court of Appeal cases. That Section 254C of the 1999 Constitution as amended, and that says that this court's jurisdiction is limited to employment, labor, and industrial relations. Since the alleged debts arose after the termination of the employer-employee relationship, the dispute does not fall within the purview of this court's jurisdiction. The first defendant applicant urged the court to strike out this suit with punitive cost for lack of jurisdiction. The claimant respondent, in opposition to the instant application, filed a 12-paragraph counter affidavit deposed by one Cynthia Mohammed, designated as legal manager in the law firm representing the claimant respondent. In his written address, the claimant respondent formulated a sole issue for determination, to which, whether this honorable court has the jurisdiction to entertain the suit. The learned respondents counsel had argued that the applicant's objection is based on a deliberate misinterpretation of the case, asserting sorry, I missed a page. Asserting that the dispute falls under the jurisdiction of this court. The claimant respondent contends that the suit arises from an employment contract and a training bond agreement, which obligated the applicant to remain in the employment of the claimant for 60 months, that is 5 years, or reimburse the claimant for training expenses. The claimant argues further that even the applicant, in her written address, acknowledges that a claim enforcing rights or obligations under an employment contract falls within the National Industrial Court jurisdiction. The claimant respondent says further that the principal relief sought by the claimant is a declaration that the applicant breached the training bond agreement, making it an employment-related claim. that the court's duty at this stage is to determine whether it has jurisdiction not to evaluate the merits of the claimant's relief, number one. That in addition to the constitutional provisions of Section 354, the sub 1, sub A of the Constitution of the Federal Republic of Nigeria, 1999, as amended, there are plethora of cases of case laws affirming the NICN's exclusive jurisdiction over employment matters, including disputes related to contractual obligations arising from employment. See Kano State Government and others versus Muhammad, reported in 2016, LPELR 41334, Court of Appeal. See also Niger State College of Education versus Imam, reported in 2022, citation supplied. The Learned Clemens Respondent Council said that it is strikes that it is the case of the claimant as endorsed on the writ of summons that determines the nature of the claim before the court and the jurisdiction of the court. The NNPC versus Feng Sei Engineering Company Limited, reported in 2023, citation supplied. In response to the applicant's arguments that the claim arose after the termination of the employment, implying that the NICN lacks jurisdiction, the claimant refutes this, asserting that contractual obligations such as reimbursement for training costs survive the termination of employment. Counsel submits that the first defendant's argument is misconceived, as this would mean an employee whose employment has been terminated cannot approach the court for payment for terminal benefits, and went further to distinguish the present case from the registered trustees of Self-Reliance Economic Advancement Program versus SADIA, started by the applicant in support of his application. There's a where a loan unrelated to employment was deemed outside the NICN's jurisdiction. In contrast, the claimant maintains that the training bond agreement was integral to the applicant's employment contract, and it cannot be disputed that the proper venue to enforce any such right or obligation arising from the contract of employment is this court. The claimant urged the court to dismiss the applicant's objection with court and assume jurisdiction over the matter. So the court, having regard to the facts of the circumstances of this suit, the processes filed in support and in opposition to the grant of the application, the court distilled the issue below for determination, and that is, given the circumstances of this suit, is the instant application meritorious and such that ought to be granted? Jurisdiction is the lifeblood of any adjudicatory proceedings. Without jurisdiction, no matter how well a proceeding might have been conducted, such proceedings would amount to a nullity. See the case of SPPCN Limited versus Arnado, quoted in 2015. See also CBN versus Odo, quoted in 2021. And Obijaku versus Obijaku, quoted in 2022. Citations all supplied. The jurisdiction of a court is conferred by constitutional provisions and its enabling acts, and not by ingenious arguments or submissions of counsel. C. KS, IES, IEC versus PDP. Reported in 2006. This Nigeria Weekly Law Report, part 920, page 25. See also Okarika versus Samuel, reported in 2013, and Sulaiman versus FRN, reported in 2020. Citations all supplied. A court, in determining whether or not it has jurisdiction, will look closely at the claimant's originating processes and pleadings, that is, the claimant's writ of summons and statement of claim, and not the pleadings of the defendant. C. Marine International Limited versus Ayetoro Bay Agency, voted in 2015. For Nigeria Weekly Law Report, at 1502, page 313. Coming to the third case, it is the claimant's case that the claimant employed the first defendant as trainee pilot by a letter dated 30th August 2019. Due to the inadequacy of her professional qualification, experience, and technical expertise, which did not meet the requirements for the role of an airline pilot, she was required to undergo some trainings, including aircraft type rating qualification rating training program sponsored by the claimant. This necessitated the execution of a 5-year training bond agreement dated the 30th day of June 2019, wherein the claimant undertook to sponsor the first defendant to relevant aircraft type rating course in consideration of her remaining in the employment for a minimum period of 60 months, that is 5 years, after the training, or pay the sum of 22,555 €54 79 or its naira equivalent as the training cost. The second defendant guaranteed the bond and undertook to pay the full sum in the event the first defendant defaults in her agreement in a guarantor's form signed on the 3rd day of September 2019. The first defendant participated in the third training and received her certificates. However, by a letter dated 16th February 2021, the first defendant resigned from her employment with Clement with the bond sum unpaid, though acknowledged by the first defendant in her letter of resignation. In her response to the Clement's demand letter, she proposed the payment of an equal sum of €500 every month, a payment plan that the Clement rejected, leading to a dispute in court. It is the third defendant's applicant argument that the only issue between the parties border on debt recovery, and the only dispute between them is the actual bond sum and the manner of repayment of same. That there was no subsisting employer-employee relationship or any dispute-related debt between the parties at the time of the course of action in this bill. And there is still no such relationship or disputes between them. And that the National Industrial Court of Nigeria lacks jurisdiction to entertain this suit because it is purely a debt recovery matter, not an employment-related dispute. However, contrary to the above, a cursory look at the claimant's statement of facts shows that there was indeed an employment relationship between the claimant and the first defendant. The statement of facts and the release of the claimant show that the case of the claimant is founded on the employment contract and training bond agreements, which was one of the essential terms of the offer of employment, as the terms of the training bond are incorporated into the offer of employment. The law is settled that in resolution of employment dispute, the court will usually refer to the contract of employment and any other document or instrument incorporated or deemed to have been incorporated into the contract of employment. The contract of employment is the bedrock on which parties to an employment contract found their action, and its success or failure depends entirely on the terms agreed or deemed to have been agreed on by the parties. See Ovidian versus Delta Steel Company Limited, voted in 2023. Sigbedu and others versus Itie and others, supported in 2020. And Umera versus NRC, reported in 2022. Citation first supply. On the issue of non-subsistence of an employment relationship between the claimant and the first defendant, it is the law that the documents speak for themselves. One would thus notice from the contents of the employment contract and training bond, as well as the claimant's pleadings, that allusion was made to the incorporation of the training bond to the contract of employment. Secondly, it is abundantly clear that the claimant's cause of action or incidental connected with employment, industrial relations for which this court is CS jurisdiction 2010. See section 254 sub C. Sorry, 254C sub 1 of the 1999 Constitution as amended. Section 254C sub 1 of the said 1999 Constitution of the Federal Republic of Nigeria as amended states, and I quote, notwithstanding the provisions of section 251, 257, 271, and anything contained in the Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters A, relating to or connected with any labor employment, trade union, industrial relations, and matters among arising from workplace, the conditions of service, including health, safety, welfare of labor, employee, worker, and matters incidental thereto or connected therewith. Unquote. CFCET Uzo versus Abubakar reported in 2022, where the Supreme Court citation was applied, where the Supreme Court held that Section 254C1 of the 1999 Constitution confers expansive jurisdiction on the National Industrial Court of Nigeria in relation to workplace matters. As mentioned earlier, it is instructive to note that in addition to the fact that the terms of the training bond agreement were incorporated in the offer of employment, specifically at clause B to D, the defendant applicant in paragraph 5 of affidavit in support, says that the training bond agreement was a part, the precondition for the third employment between her and the claimant respondent. And this fact has been well stated by the claimant both in its counter affidavit and its relief one in the statement of facts. Should one build on the distinction learned applicants council seeks to establish in stating that the instant suit deals with debt recovery simpliciter and is not an employment matter. So this court lacks jurisdiction to entertain the claimant's suit. A simple analogy may help put things in a proper perspective. Where a contract of employment is determined such that employer-employee relationship no longer succeeds, can the employee approach this court to seek claims against its former employer for emolument he thinks is entitled to but was not paid to him? On the converse, can the employer seek to enforce alleged breaches in the determined contract against its former employee? I think it will not be out of place to answer both questions in the affirmative, as both scenarios, the cause of action arose from the workplace. It is relating to or connected with labor, employment, industrial relations, for which the court can exercise jurisdiction on. It then follows that since the claimant herein is seeking at its to enforce an alleged breach of a training bond that arose from an employment relationship and was incorporated in the contract of employment, it is safe to find and hold that there is no such issue or factor inhibiting the court from assuming jurisdiction over the instance. Since the proper parties are before the court is properly constituted as to the members and qualification. It has been determined that the subject matter of the case is within the jurisdiction of the court, and there is no feature in the case to prevent the court from exercising its jurisdiction. Also, from the claimant's originating process on the face of it, there is nothing to show that this suit was not initiated by due process of law, or there is any condition precedent inhibiting the court from assuming jurisdiction herein. CPDP versus Edede, voted in 2022, 11 Nigeria Weekly Report, part 1840, page 93. Paragraph A to D. It is the considered view of this court that this court has and can properly exercise its jurisdiction over these suits as presently constituted, and I so hold. On the whole, the first defendant applicant's application fails, and the objection is overruled and discountenanced. The issue for determination is resolved in the negative in favor of the claimant respondent, and I so hold. The case is now set down for speedy trial. There is no other to court, and the parties are to bear their respective costs. Ruling is entered accordingly. That's it.
As the court pleases.
As the court pleases, most grateful, my lord.
As the court pleases, we are most grateful, my lord.
Very well. Thank you.
Thank you, my
So,
lord.
So please, when you get your copies, you now read it very well and then make up your mind whether you agree with me or whether you're running upstairs. Thank you, everybody.
Thank you, sir.
All right.
Thank you, sir.
Thank you very much.
My lord,
Yes.
I wanted to ask if we'll get adjourned dates for trial at a later date.
Yes, of course.
Okay.
Um.
Thank you very much.
Okay. Patience, are you there? Patience. Okay. Is anybody there? Da Costa? Any of my registrars? Shem?
My lord,
Da Costa?
Yes, my lord.
Are you there? You have to give me a date for this matter. Are you in the proper place, I hope? So give
my
me a
lord, they are in
date.
court.
You are in court, of course.
My
Yes.
lord, they will communicate with counsel and they will issue a date, my lord. And hearing notice to be served.
Okay. Okay, then. Cancel.
Yes, my lord.
Yes, my lord.
I hope you heard my people.
Yes, my lord.
It would appear the date to be duly communicated to you. I'm very sorry that you can't get it now. Yes,
No,
it
My
thank
lord,
will.
you can wait now. Sorry, my lord, I was muted.
Oh, sorry. Now the date will be communicated to you. I thought my people are in the court.
I am
But
here, my lord.
okay, okay, this is Patience.
Yes, my lord.
Please give us a date for hearing of this matter.
Okay, my lord. Is it for trial, my lord?
Yes, it's for trial. For trial, and if it's for accelerated hearing. Oh, so if you can even give us 2 days or give us, let's start with 1. Then we'll see what we can do with it.
Okay, my lord. May 28th. Can you
Okay.
hear me?
Yes,
May 20.
I'm hearing cancel. May 28th. Does it sit
Yes,
down?
my lord.
Is it okay with you?
okay
It's
with us.
convenient, my lord. But my lord, if I may say, the first defendant has a motion to amend their statement of defense, which the claimant has challenged. So I don't know if we will take both that day trial and hearing of the first defendant's motion.
Definitely, we will do that.
Yes,
So
ma'am.
May 28th for hearing of the motion on notice before the court and also commencement of hearing.
Most grateful, my lord.
Are we all right with that?
Oh, great, my lord. Yes, my lord.
Okay. All right.
Okay,
Thank
my
you.
lord.
Okay. Patience.
My lord.
The court has already risen. I can't say the court to rise again. I have
Okay.
risen.
Okay, my
Okay.
lord.
Thank you.
May 28th.